welcome you all for the today's program on characteristics of IPR from legal and commercial framework. To handle this session, we have an eminent speaker, none other than Dr. P. Venkatesan sir, the advocate of Supreme Court. He was a Bar Council member of Karnataka earlier. He got an hands-on experience in many laws, including IPR. 14 years experience in IPR also. When we requested for him to handle this session, he immediately agreed for our invitation and accepted our invitation and came for this virtual program. I wholeheartedly welcome Venkatesan sir. It's being a very niche area, very less members will practice in this area, but it's very interesting and but very few members will practice. But hope from this session you will take away a lot of learning. With this welcome address, I will welcome once again all of you. I request our secretary to give a brief introduction of our today's speaker, Venkatesan sir. Over to you, Pramod.
Thank you, Chairman. Well, I take a privilege in introducing Dr. P. Venkatesan. He studied at Government College, Chennai, and enrolled at Karnataka State Bar Council. And he has 12 years of professional experience in litigation and 14 years of experience in prosecution, and currently practicing in Supreme Court of India. He had a chance to conduct, participate in good number of cases before Supreme Court of India, various high courts, arbitration tribunals, debt recovery tribunal, green tribunal, consumer forum, national consumer dispute readdressal commissions, NCLT economic offences tribunals like FEMA and PLMA, litigation experience at Constitution, laws on science and technology, and laws on social issues. He also has experience in banking and IPR laws, which he specializes in, arbitration and contract laws as well. He had the opportunity to work with Indo-German project on standardization of judicial decisions by applying a scientific and technological tools. He is also given various research papers in the guidance in the field of IPR on analysis of novelty cases in Indian patent regime, current issues and challenges of compulsory licensing in India, patent valuation in pharmaceutical domains. He is also the guest faculty of Patents, Technology and IPR at Delhi Technical University, DTU, in 2014 and 2016, and Indian Society on International Law, Delhi, 2014 to 2019. His core experience is 14 years experience of handling variety of IP related issues of companies, the protection, promotion and commercialization mechanism of patents, trademarks and copyright, data protection and other IPs of company's organization. His skills includes in IPR domain, patent searching and patent drafting, claim analysis for patent the invitation, patent claim construction and interpretation for patent prosecution and litigation, patent prosecution and litigation, trademark prosecution and IPR commercialization and license. Before I hand it over to the speaker of the day, I would like Chairman to talk a few words.
Friends, I want to bring to your kind notice that the other programs of this month and next month, we have an excellent program on faceless assessment on upcoming 16. It is handled by KK Chaitanya sir and Padamchand Kincha sir. I request you to register. And after that, 23rd, we have another interesting program on cryptocurrency, VDA. 5 speakers, 2 speakers from USA, CPA and CA is attending. Another 3 speakers from state. They'll be handling taxation, direct, indirect taxes, legal matters, and evaluation of VDA. It covered end to end. Very interesting program. I request member to even register for that. We have a RRC program at Madikeri on 6th, 7th, 8th of May. I request members to register for that also. Thank you once again. Over to Venkatesan sir.
Namaskara. Good evening to one and all. Thanks for being given an opportunity to be with you. So what I will do is, instead of going in detail with the different types of IPR, how they are created, how they are protected, and how they are commercialized, and how they are taxed from the IP perspective, I will try to see how to connect different dots. Very important, because you can get the exposure of the patenting process and the copyright process, trademark process, both from prosecution side as well as from the litigation side. They can give you the overall idea. But what I will do today is connecting different dots. Very important, actually. Most of the people who are practicing specifically in as a CA or company secretariat, they are having disconnect from what they are doing practically. So I am seeing what they see and what they understand is thoroughly different, actually, and what they practice also. I mean, only few people are very naive to get the idea of connecting different things. So what I'll do is, from my personal experience and what I learned through our different sources, I'll try to connect it so that we can get an idea in a practical applications. That's my main objective today. So you people can pitch in with some questions whenever possible, or you can put the questions at the end of the session so that we can take it lightly and we can discuss thereafter. So prior to getting into the exact types and definitions, I want to say one thing. Now, Enforcement Directorate is trying to strengthen some acts to ensure that no antisocial activities are carried out in the name of intellectual property rights. Very important. Actually, earlier we could see that there used to be money laundering, there used to be wallet transaction, there used to be umpty number of illegal or unlawful transactions in the name of violations of certain copyright issues or making some duplication materials or something like that. But nowadays, the main funding and main transactions are happening in the name of intangible property. I won't say intellectual property. Intellectual property is a narrow domain. Intangible property is a broader domain. So what I will say is, in the name of intangible properties or intellectual properties. For lighter understanding, you can connect intangible property as intellectual property just for your basic understanding, but both are not same. What I have to say is, intellectual property can be part of the intangible property. That's what it's a intangible property, a very big, broader domain in a way. I will say how those are highly connected. So to make ourselves understand, now what I'm saying is a property has been created. Whatever you are seeing the real property, that's different. Intangible property is created. I will say intangible property. The intangible property is created. Once a property is created, a value is attached with it. Value is attached with it. Once a value is attached with it, there comes valuation. The process of valuation. There are no unique process of valuation, and there are different procedures and different methods. And it cannot be done by a single expert. It's a collective expertise. I can say it is a product of collective expertise. So different people have to come together to evaluate, or we can say they evaluate to get a value or to carry out a valuation process in intangible properties. So if someone is trying to give undervaluation or overvaluation or different valuation than what it is, then they will be charged under new enactment of money laundering. Very interesting, because liability is there on professional also. More liability has been now put on the professionals, specifically on lawyers, chartered accountants, and those professionals and valuers, those professionals who are carrying out such kind of valuation of intangibles. I can say intangibles. So in this background, I am taking you just to say that whatever we have understand, the types, naturally what we say is copyright, trademark, patent, geographic indications, trade secrets, what do you call the Design Act, the Designs Protecting the Design Acts. These are intangible properties. Yes, those are intellectual properties. Yes, they are intellectual properties. To make ourselves understand, a person is a boy or child is born to parents. A child, when it grows, it will acquire different characteristics with it. Became a boy, thereafter a student, thereafter he will get a job, thereafter an officer. Then the associated nature of character with that boy keep changing as it grows. The life period of a boy is limited. It may be 60 years or 70 years. What I have to say is, during the process of the life period, during the process of a life period of a boy, the nature of the characteristics of a boy can change, as well as the nature of the liability and the nature of the value associated with a boy will keep changing. He will become a father, he will become a grandfather, but in official capacity, he will do some work which is assigned to him. So we can see that a person within a period of life, he can see a various characteristics or natures or job or liability associated with a person. Now, I am talking about a living being, but what I have to say is same is the case in intangible properties. So generally, intellectual properties, I am trying to loosely use it, intellectual property and intangible property, so that you can connect it. So what I'm saying is there is a life period for each intangible properties. So, what they will try to say is the life period is associated for the purpose of, very important, it cannot be everlasting. That's the things. But the purpose that it should never be over exploited. That's very important criteria. It should be reasonably exploited by the creators. So I can broadly say that intangible property can be, I'm loosely, diversifying them into two things. One is the intangible property, which can be protected under statutory norms or statutory laws, and the intangible properties which is not protected under statutory norms, but that can be protected by other means. So what I am saying is, I'm just reading out something. We can okay, some kind of things you can see that. So it should have the limited life period. All the intangible property should have limited life period associated with this. So these are the characteristics associated with all intangible property. One is life period, limited life period. Another is during this life period, very important, it can be transferable. So it should be transferable. And during the process of its life period, it should generate some income. Okay. During the life period, it should have a limited public interest also. It should serve some limited public interest. So these are certain, what I can say is nature associated with the intangible properties. Now, what I can say is this, these are generally in case of statutorily protected intangible properties. Whereas in case of non-statutorily protected intangible properties, I will say what do you mean by statutorily protected and non-statutorily protected. For example, in case of statutorily protected, I will say there is a defined laws, latum, which protects patents, some kind of intangible like patents, copyright, trademark. In India, trade secret is not protected by acts, but rather by other means. And Designs Act, there are some statutes which gives these characteristics like period of protections, transferability nature, and generation of income, and some public interest associated during this period of its life. Now, what you can see is there are some kind of intangibles which are derivative of these intangibles, or which has come during the course of this presence of intangibles during the period of this statutorily protected intangibles, which cannot be protected by any statutes, but it can be protected by other means, like a kind of activities associated with it. It can be of any nature. I will say that When a intangibility or intangible property is created, it will start with some single things, but it will have some bunch of things associated with it. Bunch of rights or bunch of different nature of transactions, It cannot be with a single transactions. It can have multiple transactions. To make ourselves understand, for example, there are 3 different claims. I will tell you what you mean by claims when you go to patent. Claims is like what I'm saying, the core of the patent. So there are 3 claims in a patent. One person wants to license the patent to someone. In a way, what I'm saying is there are 3-story building. It is not possible to rent out the whole house to a single person. Someone wishes to have the first floor to be rented, someone wishes to have the ground floor for renting, someone can have the renting for 3rd floor. In a similar way, I am giving an analogy. In a similar way, we can see that there are 3 claims in a patent. Inventor got a 3 claims in a patent. He can license, or he can assign, or he can do any kind of commercial transaction with any one of the claims or 3 claims in totality. That's very important. So we cannot say you have to give me all the 3 claims. It's not possible at all. And most of the business cannot happen in such a way, because some people, if they are trying to get these 3 claims in a single shot, the expenditure will be very heavy. And for example, there is one claim which is sufficient for them to take it, the license it, to take his business to next level. That's more than sufficient. Why should he unnecessarily license, get the 3 other 2 claims to be licensed for no use? There should be some use. There is no commercial activity associated with another 2 claims. So I am making so simple that you have to understand that we can part by part do the commercial transactions. Very important. Part by part. That has to be associated with some kind of assignment or some kind of license or some other things which can make sure that that in totality, if not possible for commercialization, the partial portion can be created out, or it can be extracted for commercialization. Now, the value of, for example, to make ourselves understand, the value of the whole 3rd floor, 3-floor house is 1 crore rupees. But he wants to sell the 1st floor, then or license it, I mean say lease or rent, you want to sell it, he can do same thing. So he can do as he wish. Now similarly in a patent or any kind of IP or intangibles, I can say intangibles, similar activities can be carried out. But the professionals are not able to understand these concepts. Those who are very professionally connected with intangibles, that we can see from European countries or advanced countries, developed countries, they are doing it so that they cannot, if a person is making out all the house, he cannot sell out all the house, or he cannot rent all the house. He may be needing for himself for using a certain portion of it, remaining he can sell it or license it or whatever, rent it, whatever. Similar way in intangible property also can be done. That's what I want to say. So if that is the case, the value of the things, for example, I am connecting to the house so that you can understand this. You can analogically connect it to other intangibles. So what I'm saying is a portion of intangible can be assigned to someone, can be licensed to someone, can be sold to someone. I can say can be permanently sold to someone, or they can do something similar way. In all intangible assets we can do it. And why these things are possible, the value may also change. Now the value of the whole 3 claims in a patent changes while assigning or licensing or selling it, but that need not be possible. The value may differ when they want to, a portion of it has to be licensed or assigned or sold or whatever, the value may change it. But the valuation is a very critical issue, and the taxation issue, and when it is protected at one place and it has been transferred at another place and has been licensed another place, there are a lot of multiple legal complications and a lot of multiple valuations. For example, a pen may be in India 10 rupees. In the same pen in Europe, it may be different, £1. In the US, it may be $1 or $10. It may change. What I'm saying is, for example, let us presume that in India, 1 rupees, in Europe, 1 pound, and US $1. But the value of those one may be same, the base may be same, but the value associated with the one, this one is not equal to 1 rupee, is not equal to 1 pound, and 1 pound is not equal to $1. So you have to see that one. That's how intangible property, when it revolves, when it makes a business transaction in different jurisdictions, it may change. Moreover, the components, when the part of the associated intangibles, a portion of the intangible, when it has been licensed or sold, or it may also change. That's what the value, there is no fixed value, and other things also associated with that one. What I have to say is, it is not just with a single thing. You have to understand, very important. When you buy the cycle, we buy the accessories. When we buy the car, we buy the accessories. Now we can buy the cycle from 3,000 rupees, small cycle, to 3 to 4 lakhs, 5 lakhs also. What is the value? The same thing, but the component, the value associated with each component of a cycle varies and changes. Same is the case with intangibles. I can say, same is the case with intangibles. When we are trying to buy one intangible, we may not buy that single intangible. It's not possible at all. Generally, it is not easily. Sometimes they may need only one part of a claim in a patent, they can buy it. But they will try to connect other things also, copyright associated with it, trademark associated with that patent, and any other IP associated with that patent, or with that patent also be, those things are also to be transacted during the business transactions. Now, the value connected with the single claim is not the correct, and other associated accessories, those are all called non-statutorily protected intangibles. I can say that is not intellectual property. That's a kind of intellectual properties, but I'm giving a broader definition. It's called intangibles. I'll read out some of the things so that you can connect it. What are the different type of intangible properties? Non-statutorily protected intangible properties, which is created during the course of, I said, a child is born, and it will take a different course of nature as he grows till his death. In official capacity, in a family capacity, in a nationality capacity, in a religious capacity, in a linguistic capacity, he may take a different nature, the same person, and he may add value to his own life also, by his morality, by his professional ethics. He may add a value to his own life. Similar way, we can see that intangible property during the course of its period of time, it is not single thing which transfers. It will try to generate some kind of associated things with this business. To make ourselves understand, a trademark is created. Tata Salt is created. Is one of the trademark. I am taking the simplest thing to make ourselves. Tata Salt is one of the materials sold. Tata is a trademark. Salt is one of its products. Now they are giving a name for it. But during the course of the time, we can see it is patented product. Okay, it's a patent. But it's a trade, it has associated trademark also with it. Fine. During the course of its, very important, during the course of its business, you can see that over a period of time, it will evolve with certain values associated with it. For example, there are some technical things like the minimum level of iodine, or minimum the different traceable elements which they should maintain and which should they neglect, which is more harmful to human living things, which may generate cancer during the course of regular consumptions. Though they will reduce those things, because what you can see is they will try to add a value to that salt. It's not just a salt sold on trademark of Tata, or which is sold just on patent. So what you can see is a value is created along with it. Those are called technical values. Along thereafter, a goodwill also created along with it, and there will be a customer connected with it. Buyers will be there. We can see that. Now we can see easily. You can, with this present data world, we can easily understand that who are all the buyers, and the nature of the buyers also. In the city, how much they can, overall the maximum buyers in cities, in which type of cities they are sold, and what are the goodwills, and why they prefer this Tata Salt, and those things. I am saying there are associated characteristics will try to fix with it, and it will travel during the course of the business. Now, a salt which is manufactured at a cost of 10 rupees, he will add, he will try to get some profit out of it, the name, the brand of Tata. But during the course of time, he will acquire some values along with it. It may be a technical value. He may fine tune the quality of the salt also. And thereafter, he may packaging or appearance. There's a designing around things. So he may collectively changes things. Now, you want to go to next level of business. You want to get it franchised actually to different business people, so that they can do the business, because if he feels that it has to reach to the grassroots level, so he's doing a strategizing things. You want to license it. So the value of the product is not just the patented things or trademark things of the data. It is having lot of associated accessories, and therefore the value associated at the initial stage will keep evolving, not with just the parent or core thing, but associated things with that. Let us see, I will read out some of the things so that you can understand how the values changes, so that you can connect it. Technology related things, it may be trade related things, it may be market related things, it may be customer related things. Those values, those character things which are evolving or acquiring during the course of things. Benchmarking of intangibles. What I am saying is, during our childhood, we might have seen the Reynolds, the fine writing tips. Now it has, I mean, during the other pens have come, and it has, the market has come down. Thereafter, now it started picking up in the market. The fine writing. Thereafter, now gel pen has come. They have shifted to gel. So they keep changing actually. And the ink, the quality of ink, how long when it's written over the paper, how long, whether 20 years or 30 years, that's one thing. The sticky nature of that paper. There are different papers. They use glassy papers, thick sheets, thin sheets, and rough sheets, all those things. And now it, so they'll try to have the combination of the ink, so that it will try to get some 80-90% of the efficiency. So now what I will try to say is there will be international standards. I want to say every technology, most of the technology which are in the market, business market, they will try to benchmark them actually. They'll keep on increasing the standards. That's called, you might have read about legal metrology, which is one of getting more demanding globally, because we cannot sell the low branded materials. There should be some standards fixed, and the quality, the service of that one, and many other connected things. So the benchmarking of the intangibles, we can say, and the technical support services. There are some good services, that annual maintaining services. So like that kind of marketing of intangibles. So skilled labor supply with it. For example, now we have, what is it we called solar energy. That's reached a good to a good level in the market. Now they are going to the lithium ion battery. Very important. From the lead acid battery to lithium ion battery. Now they have to, storage capacity has to be increased, and it needs a skilled people in this one. So any kind of intangible property, or I can say intellectual property, will evolve with certain kind of intangible property with that one, like skilled labor supply. It may be some, even it can be connected with any domain like hospital. So there are special experts in art surgery, experts in art surgery. So or like that, different. So or body transplantations, organ transplantations. Some experts are there. So the hospitals, if they are very expertise, acquiring expertise during the course of their existence by doing the organ transplantations, or we can see the acquisition by experience, one, and employing some acquired, I mean highly skilled people or skilled people for its existence itself is an intangible property. So what I'm saying is, while they are going for marketing of admitting the students in the schools, there are a lot of things. We have a highly qualified teachers. We have multiple linguistic teachers. We have 1-to-1 ratio teachers, caring teachers. And the teachers with good English or good language skills and highly exposed with a different international standard of educations, with a good training, these are the skilled acquired. So it becomes intangible. That cannot be protected under statutory laws. I have to say these things. Same is the case, data mining, data transfer, IT enabled services, knowledge processing outsourcing, Indians subsidy of foreign parent, foreign companies. So this becomes, though it is a company with a different entity, but it becomes a kind of intangible property associated. For example, to make ourselves understand, there are now a company property has become 70-80% as an intangible property. They don't want to have the physical property, real property like buildings, all those things. They are going for Google, like a Google or Yahoo. They are just depending only or 80-90%, we can say, on intangible property, because it's mostly on software and technology and patent materials and trademarks. So those kind of things. So what I'm saying is, and very important, for example, if they want to sell the company of Google or any kind of subsidiary of Google, which is in India, they can want to sell the company to in someone name. For example, Veriton Software Limited or Verizon, it is there, I can say. It was sold to Yahoo. Yahoo bought it, and these are the IT enabled services and software. There are some things which is skilled labor also. So they just not bought the trademark or any of the company property. They bought not just software. They bought all these kind of accessories which acquired during the process of their business, or which occurred as additional subsidies or subsidiaries in this one. So there are many such things. I mean, what I'm saying is goods and services, research and development services. For example, a company is having good research and development services. Apart from that, becomes a kind of intangible property to the company. For example, Google is having a good research communities. Then it became intangible property of the things, because skilled labors, that output what they are trying to generate, all those becomes intangible. So there are umpty number of things. I am not going branding services, all those things. Now we can see that these are different connecting things. It's intangible property cannot be a standalone one. It cannot just be alone on which they can do the business. There are associated things. So an intangible property, or I can say a statutorily protected IPR has been generated, and along with it other intangible properties are created, and thus the value, money, manpower they spent on it to generate it is different, and the business market related is different, and but the associated things acquired by way of other intangibles, either by during the course or during its existence, will give the change in the value of the intangibles. That's very important. Now, what I have to say is, everyone has the life. Dogs have life, elephants has life, every animal. Same is the case as a living creature. You can see these all the intangibles also have the life, but statutorily protected intangibles has a life that has been assigned through statutes, like patent 20 years, copyright 60 years. There are different within that one, life plus 60, and there are different criteria. So that has been created by statutes, and it can be altered. Very important. It can be altered. The life period can be altered, because it becomes a legal entity. The life of a legal entity can be altered, subject to the policy of the country. And very interestingly, it has to sync with international standards. Very important. It has to sync with international standards. A man, what I'm saying is, this is a pen. This will be a pen all over the world, but it may be named differently. So I am giving a pen is named differently. Functionality may be same, but naming may be different. The way of utility, the way of its value may be different. That's the thing. Same is the case when IPR is created in a country. So it has to be protected in each country. And the standards, what I'm saying, the value associated with the standard to fix its things will keep. There is a universal standard. Globally, they want to fix it, a kind of writing instrument, but the name may change it. I am saying just for our basic understanding. Thereafter, I will take it to the patent. Then now 41. So what I have to say is the value associated with it will change it. That's a different. It's in from the perspective of valuation, but the quality, or you can say the quantity, other things also will keep changing, but the naming also will keep changing. So the characteristics will keep changing. So a person, I mean, this pen may have a different jurisdictional value and statutory value. Same pen will have a different statutory value. And moreover, to avoid different values in different countries, there are some universal benchmarks or standards, you can say. It may be in case of patents, or it may be in case of copyright, or it can be in case of trademark. It may be for any statutorily protected intangibles. I'm not talking about the non-statutorily protected intangibles. I'm talking about statutorily protected intangibles, where they want to fix the value associated with the same thing to have international standards. For example, to make ourselves understand, in case of patent, they try to have patentability criteria. That's called subject matter, novelty, non-obviousness, or you can or inventive step in India. What do you call, say? The name is different. Here we will call it inventive step. In Europe, they are calling inventive step. In US, they call non-obviousness. And utility. These are the basic things. So when an invention is there, this criteria has to be paused to get the invention as a patent. Otherwise, that is invention only. Whether it is patentable or not. Statutorily, there are some benchmarks kept in India. Globally, such benchmarks are kept all over India, all over the world. But for example, novelty, the standards are not uniform all over the world. They're trying to fix the standards. So what I'm saying is, a patented protected in India may not be protected in the same manner in America or in Africa or in Europe. The standards varies. So the value will keep changing. So a person wants to do a business in any of this jurisdiction, he has to protect the statutorily protected intangibles. It should be, if you want to do the business in India, he should have the patent right over the patents, or he should have the trademark to be registered. Same is the case with the copyright. Copyright is slightly different, I will say. Same is the case of copyright and other Designs Act, what other things in geographical indication, GE also. So what I will say here is, the value keep changing, and they are trying to keep some, trying to keep some kind of standards so that it will have some kind of value. That value may not fix, may not fluctuate a lot, so that the value, for example, the value which has been created, say at patent at US, should never be under value or different value very much. It can have a different value, no doubt at all, but should never have a different value. Well, valuating to give a patent for it. Same is the case, it should never have a different value. Now that's the reason they are going for a universal or international processing of the patents, so that they will have a uniform or closer to the international standards. They're trying to levitate the standards so that they'll try to fix some kind of uniformity. It's very difficult to have absolute uniformity across the world, but they can have less variance. That is the basic behind that. And taxing also, in the similar way, they're trying to fix in case of the intangibles that you people are expert, you can understand it. So now jurisdiction value. Why? We have to understand. We cannot protect intangible all over the world. I want to protect this pen, this by way of patent. I don't want to protect in a country where they depend mostly on pencils. Why should I protect it in different countries where they consume, where they use different materials, where they use different materials for the ratings? So I have to see the marketability. Very important. Otherwise, I have to renew it, keep renewing till 20 years. They kept, for example, 25 years, let us presume. So they are 20 years. Period of the protection is also trying to be a kind of uniformity, not a standard, I can say, uniformity of protection of life, so that you should not, for example, a patent is protected 10 years here. In other countries, they are protected for 20 years. Then when it is protected over there, then there will be a clash, legal clash, I can say, not a jurisdictional clash. I will say you, when you understand, when I'm giving an example, if it has been protected, pen is protected 10 years in India, with a jurisdictional limitation period of 10 years, protection period of 10 years, when the same is protected for 20 years, but I'm in America. So after 10 years, I cannot do a kind of business. Business is not, it is in a public domain. Anyone can take it and use it. But in America only I can do it. So when I want to do the international trade and transfer or business or commercial activity, they will see that. They will try to the one which has been already protected for 20 years cannot be sold in India because it is already got lapsed, or its period got over. So that's the things they'll try to find out some reasons to connect, or I mean to have a uniform or a closer level of protecting the what you call the period of its life of the IP materials. I mean IPR, statutorily protected IPRs, but it is not in case of non-statutorily protected IPRs. Those are regulated by other laws like contract laws or business acts, many, or business acts or international trade acts, like that of those kind of acts. But the protection here, why they have given a life is because they cannot keep on I mean holding their rights forever. It has to be after certain usage or after exploiting for certain period of time or period, it has to be put in public domain so that the next level of creativity will happen over there. Very important. The next level of creativity is very, very important in any kind of, because they are blocking this time for two purposes. Just the people who have invested time and money and manpower has to get something back. That is the purpose. But it's not possible in every IPR they will get some kind of, all kind of what I'm saying, investment. There is commercial perspective. I'm not getting into that one, where only a limited portion they are able to make commercialization, or they can generate revenue. Remaining portion they will encounter loss. Now that's a different topic altogether. But what I can say is also, moreover, the case of patent, I can say that a case of patent, it may be protectable in India. For example, as a patent, it can be protectable. Software inventions are not protectable unless they have the technical advance or technical solutions which can be solved using that patent, using the software. Per se, software is not protected, but in US, software is also patentable. Anything under sun is patentable. That is a general concept for them. What I'm saying, software is patentable there. So the criteria, what they're trying to fix, patentability criteria there in US and in India are same, but subject matter varies. Very important. The subject matter varies. A person can be called as a good boy, or he can be called as a drunkard, or whatever. He may be religious, or he may be very orthodox, or whatever, based on certain characteristics associated with that person. Same is the case. That's called a subject of a person. Is a good man, is a religious person, or he is more like that. Some such a subject of a person. So it is subject to some certain characteristics associated with the person. Same is the case in case of patents. The subject of the patent is subjected to the claims, what it reflects. So that is the reason there are good inventions which may be protectable, which may have commercial value. For example, there are nuclear things which have good inventions which are highly commercial, but it is policy wise it has been not patentable in India. So the statutory criteria are there. Those are the inventions, though it can have all the patentability criteria, but it's not patentable in India. In the sense it's barred from getting patented for various reasons, for national security or for maintaining some good, maintaining some law and order problem. So there are certain things actually. There may be many reasons, but there are non-patentable inventions. That is again, inventions are those are the patentability criteria, but they are not patentable for some social reasons or for some other reasons. So what I am saying is, these things are subjected to other a kind of see these things have to, so pattern all the intangibles are, I can say, as two nature. Generally broadly you can classify. One is having a service nature and another is of having a where you can do the business in the of this intangible in the nature of goods and in the nature of service. So very interestingly, GST has given the definition for goods and service. I'll read out that one, whether how you would understand that one. Okay, no problem. So what I have to say is, they are given the fixed the character of the intangible as either goods or service. But we'll in GST we'll see will be called classification. We can see the classifications. Here also in trademark different classes under which it can be protected. Same is the case in patent also. There are different classes under which it can be protected. What I have to say is the intangibles, whether it has having a service kind of nature which can give the output. Output should be in the form of goods or service. Whatever the, for example, to make ourselves understand, Yahoo, Google, all those people are service providers. We could not get anything out of them in form of goods. They're service providers. But there may be goods associated with intangibles. For example, Amazon. So it has two business associated with that one. They have developed a software in such a way it gives service, but the goods are not created by it. So, what I'm saying is, while assessing them, we have to, it has the service character or goods character. The intangibles are intellectual property rights on which they are carrying out the business, on which the taxation is carried out. Very important. We have to see the what I'm saying is the composition. This as the composition of a composite character. Whether if it is serving only the intellectual property on which the business is carried out, it has only which is dealing with only goods. For example, a patented pen is only sold. Okay, fine, no problem. It is of having the intangible property of which deals with only goods, but a service associated with it. For example, a group of skilled laborers who does some service for it, annual maintenance, all those things, that becomes service component. Very important. So Tata is selling, for our understanding, refrigerator. So the main business is with patent refrigerator. So, but they do service for it for annual maintenance, whatever the things. But the main business is goods, patented goods. Allied thing is only service. That is generating hardly 20 or 30% of the income. But 80-90% of income is generated out of selling 90% of goods. Patent out. Or both are, what I'm saying is, the skilled person also became intangible, but both are working out to sell the products in the market, but which path takes more dominant. That has to be considered whether taxable under goods, those IP has to be taxable under goods or service. Because there was a serious debate on this one. Many people are saying, no, it has to be service. It has to be taxed under service, it has to be taxed under goods. And within the goods, there are different classifications, and same is the case with the services also. I'm not getting into this one. What I'm saying is, when the composite things are there, when there is a combination of 2 or 3, like that we can see how to bifurcate and which component is more dominant on which it has to be decided. That's what I want to say in case of what I called categorization of the IP under GST. Same is the case with, now I am going to discuss about different technologies and also how it has to be connected. For example, IP is statutorily protected and it's of jurisdictional nature, very important. It's of jurisdictional natures. So a patent which has been patented in India, unless it is protected in different nations in where one has to carry out the business, they can do the business, but they cannot claim the right over it. So they cannot claim the right over it, or the legal right, I can say. They can do they have the right in other manners, like right accrued by way of agreement or way of any business transactions. They have the right over that one, but not in the right on the patent. So it's a jurisdictional perspective. So now we can see that those who want to have the what you call a business out of that one, they have to see that whether it has been protected under jurisdiction so that they can have the right over it. Now, with the advancement of technology, there is, I can say, there are lots of issues, challenges, and complexity in case of cloud computing. So I can say in clouds where we don't know where is the actual physical, where is the actual physical position where it has been actually physically placed, where you can get the documents from them. For a way, what I'm saying is, a software has been protected under Patent Act, but which has technological advancement or which can solve technical problems as a patented in India, but that has been on cloud. We don't know where is the actual physical portion of the cloud, but is generating some revenue. From the tax perspective, there are a lot of complex. Where he has to pay the tax? One is because his registered office is different, the place of generating revenue is different, all those things. To make ourselves understand, and the agreement associated with also difference. To make ourselves, a man is moving, a shadow will follow. One of the important judgment, case of poster-based judgments, is trademark related, IP related judgment actually. Now I think that is a basic jurisprudence, and now it is going to evolve further. What I have to say is, yeah, there are different IPs protected, in different parts of the world, but they will go to tax havens or country where they can save more profits, I can say, because there may be more incentives for carrying out the business in the name of intangible assets. So they will give more benefits. The countries which are, people are more aware of the tax havens where they will try to exploit them, that situations. So they might have protected here. They will protect there also, or they might have protected some other countries. But they will transfer these assets to country by way of agreements or international transactions. It will be protected in some other countries where they can get more tax benefits. From there, they will do the business to India, same India, where they started originally in India, but they will do the business in India. What I have to say is, here, the connecting things, protection is different, licensing is in different nations, but same licensing is given in India. For example, it has been protected in India, it has been protected in US, it has been protected in Europe, but licensing is given to Australia, where it has been protected Australia. So licensing has been given to Australia, but Australia company has a company at tax haven countries. From there, they will do the license to India to do the business. It has been originally protected in India. Now we can see the connectivity, how it happens in the business transactions associated with the intangible assets. So we can easily understand that it is not just protection, it is rather the business connected and the tax connected issues with that one, and the valuation, because now they will change the valuation. It's not valued same like what, because now it will be in international transactions. It may be in a pound or dollar, it's not in rupees. There the value will change. There are the taxing things and other nature associated things also. They will also keep changing. Now where it is to be paid, the tax it has to be. These are the connected things we have to understand. Shall we break for a while for 5 minutes? You don't mind? Hello? Hello, sir. Hello?
Sir?
Sir, shall I break for 5 minutes?
Yes, sir.
Otherwise, give me 5 minutes. Okay, 3-4 minutes, I'll be back. Thank you. So, sir, am I audible, sir?
Yes, sir.
Okay, sir. Sir, am I able to make myself to get some clarity over what I have spoken so far? to some of, there are any questions right now? Or shall we get the questions at the end of the session?
No questions, sir. No questions right now.
Okay, sir. Okay, sir. Then I will proceed, sir. So what I am saying here is, so the issue here is, it has to adapt with some technology. In case of cloud, we have taken an example. We don't know where it is physically located, because there are mirror reflections, or I can say mirror copy. You can get it across the globe. You can sit in America, you can get the same copy, access through the clouds, and same with Australia and India. So you can do the things. You can access easily the cloud. So he's having a kind of so what I can say is, we can see that a kind of connectivity has to be understood, just not creation of the IP, but how to value it and how to connect it from the perspective of business, and from the perspective of agreement, from the perspective of taxation, and from the perspective of other transaction associated with it. So it is not so easy with the advancement of the technology. That's what I want to emphasize here. And moreover, we can see that if a company is established with the other real properties or tangible properties, I can say that there's a proper word. Tangible properties, it has to be fixed in any jurisdiction, and thereafter we have to carry out other statutory requirements. We have to comply with other statutory requirements, but we can easily fix it out. The complexity is very less over there, whereas it is more complex in case of intangible assets and associated business from this perspective. So we have to evaluate the things from this perspective, and moreover, as I said, well, during the international transaction carried out on those, or international business carried out, or international commercial activity carried out on those intangible things, the value will change. If a person is carrying out a business with selling out 1 rupee in India, the same pen, when he is trying to sell the same through a different production in different countries and different agreement altogether, which has been produced, protected in India, and he wants to sell the same in India, the value is not 1 rupee, but the agreement will show maybe 10 pounds or hundreds of dollars. So what I'm saying is, the value for the same thing will change for the associated business commercial benefits associated with it. That's what I want to say here. Now, this is one thing, but taxing purpose, for example, how to tax the income generated in case of revenue using or revenue generated in case of intangibles which has been fixed at some place, which has been generating some other. In case of cloud computing, and see, cloud computing very complex, and you can see that all over the world, specifically Europe was trying to tax Google. Actually, that was one of the important tax case. You people are aware, and you people are working on it also. You may understand those things, but to evade the tax, very important, they will try to fix some liabilities over this one. I'm talking all those things from the perspective of the practitioners, practical application of the for this practitioners. Liability is very important, as there are very many challenges from the perspective of valuation of intangibles. Same is the case with the liabilities associated with it, because as it transfers across the countries, across different boundaries, the liability will keep changing. What I'm saying is, they will have multiple liabilities. They will try to transfer those liabilities in different countries. They may be doing many business, more income is generated in India, for example, for a patented product through this different chain of transaction. But there are certain liabilities in other countries because they have to manage assets. Very important. Creation of intangible assets. There are certain amount of money spent over there. Creation, What I'm saying is creation or generation, we can say. Thereafter, maintenance, very important. We have to pay the fees for renewal for all these IPs. So they have to face that's called maintenance amount, I can say, to make its life, actually, to make the life of these intangibles live, they have to spend some money. For example, to keep it alive for 20 years. That's the reason we could have seen many of the companies, they will put their IPs in public domain after certain years, because they may assess these things hereafter is no way going to generate the revenue, and even if it's generated, it is going to have no much impact on its other business. So it's called a bunch of IPs has to be managed. So in that perspective, what they will try to do is they will put certain IPs in public domain by not renewing it, or even if it's renewed, they put it because they don't want to, because they have to spend more manpower, money on this one to manage it or to maintain it. So they will put it in public domain, or they'll get it lapsed actually. I mean, by non-renewing, it will automatically get lapsed, or they will make it abandoned. Something they will try to do so that the money spent over that one, because they are not handling one or two intangible assets, they are handling umpty number of intangible assets. So they will try to see how to put down the liabilities. Now, income is generated in India, 90% income, for example, for our understanding and liabilities. Liabilities across the world, they will change the value of the liabilities. That is in dollars, another thing is in euro, all those things. Pound, in London, we'll have the pound, in Europe, we'll have the euro. So there in America, we'll have so the value will keep changing. So they will put the value of the liabilities in different denominations rather in rupees, so that they will try. So what I'm saying is they will try to balance both the valuation of intangible assets and liabilities of intangible assets, so that they will try to put it in track so that they don't want to pay much on that one, and they will get more profit out of it. This is one of the things. And this, if such things are carried out and doing through illegal ways, different, which comes under economic offense, like PMLA or even FEMA, all those things. But doing anti-tax activities, I can say, these are the things which that will be. So as a professional, we have to be very cautious in handling the things from the valuation as well as from the liabilities part. We cannot mix the things and give a wrong information to authorities, and we should be very, very cautious in handling those things. And another thing is, now as the technology advances, very important, data protection is getting more, but there are no, I mean, good laws on data protection actually, I can say. Now, so what I'm saying is, under these circumstances, if there are data is also find a kind of intangible assets. Now a business has been, many businesses has been carried out in the name of data. So data, it can be, so extracted data and processed data, those are different things. Specifically in a kind of patent is created where it handles data and it extracts data, and then it try to give different answers where it can try to solve a problem. Then it's protectable in a way. So I'm just saying it loosely, but what I'm saying is, which can software can be protected when it try to solve a kind of giving a kind of solution for a problem. So they're trying to analyze the data. We are dealing some of the agreement where I'm saying where they're trying to extract the data, raw data, and try to extract from those raw data and try to derive some information out of that one, and they try to forecast something which are very important information for survivability of the business and survivability of the institute. So we can see that these things are whether protected or non-protected, but having a very major impact on the technological advancement. Very important. Blockchain technology and cryptocurrency, all those things are having a, it may be created as a technology, but what I'm saying is it has having associated things along with it. So a kind of protection is not only there, but a kind of liability and value and revenue generations also keep distributed across different jurisdictions. So there are complexity involved in this one. Just mere protection doesn't mean that your business has been protected. Rather, it has been rather facing a lot of complexities associated with it. And artificial intelligence, deep learning, technologies, deep data mining technology, deep learning technologies, and blockchain technologies also all are having a impact on the already created IPs on which business has been carried out or commercial activities. We have to see that in such a way how to make sure that whether those technologies are created, IP has been created, and how the intangible impacts has to be connected with it. So these are the things I want to say. Now I'll take back you to the basic idea as you people may be understanding about the things, and moreover I want to say some more things also in this one, how the doctrines will keep changing. So what I'm saying is, whatever the proposition doctrines, the jurisprudence keep changing actually. It is like contours. It will keep moving from one place and then it will try to have a kind of turn, then comes over, another turn, again turn. It will keep on moving with some changes. A doctrine has been proposed. There are many doctrines proposing intangible assets. Very important. People cannot stick with the doctrines that has been adopted. It may be suitably adopted. As a practitioners, we have to be very cautious. It may be suitably adopted. So we have to be very bold enough to say that this is not, even it may be suitable, you have to be cautious in handling those things. This is, in law you can say nothing is perfect actually. No outcome is perfect, absolute. We cannot say everything is absolute. The doctrines which have maybe looking it is absolutely fitting, but it may have slight variations. No similar, what I'm saying is, in society, no two similar problems are same. What I'm saying, no two problems are similar. It may be have similar, they are not same. What I'm saying is, I will recorrect myself. No two problems in any society, in a jurisdiction, in a legal perspective, I'm saying, no two problems are not same from the legal perspective. Yes, it may have similarity, but it need not be same. That is very important. In this angle only, you have to see that once the doctrines proposed in one similarly placed problem need not be adapted or applied to the similarly placed problems. Small variation can give a different things. It is keep evolving. Whatever the standard they are trying to fix for novelty in a similarly placed may not be same. It have a different variance and we can get a different output, and we can, so that's very important things. You people have to keep the things moving. Now with these things, what I have to say is another 40 minutes. I will take you to some other, shall I talk basic things about patentability criteria and the issues involved in this Patents Act? Okay. So what I'm saying is, in case of patents, because that is what you other copyright trademark you will get idea. Patents, I'll take you to patents. See, the inventions, whatever they are created, all the inventions are inventions. The quality of inventions may vary. The quality of inventions may vary. The value associated from the legal perspective for granting invention as a patent, very important. The patents are inventions. All inventions are not patentable. The patents have the invention characteristics, but all the inventions are not patentable. Anyway, what I'm saying, the reverse is not possible. So there is a big block over that one, so that they will say that okay, fine. To make ourselves understand, there is called nanotechnology. That the applications or the phenomena happening at a very nanoscale level, where they will try to see how the basic things are happening at nanoscale level, and they will try to see how it can be applied, those nano-sized materials, how it can be applied in the technology to get some outputs. Very important. What is the fun in having the technology? There is nothing great. Just up down process, up to down process by mechanical or chemical method, or down to up. We can build the bigger things. What I'm saying is they'll make the bigger, smaller things from top down process, or top down. It may be in a mechanical manner, or it may be chemical manner. Same is the case. It can be the bigger thing can be built using the smaller things, but easy to say, but it's very difficult to create smaller things by these manners for all the materials. It is easy to say, but 20 years back the scenario is different, where even the creation of smaller things from the bigger things and maintaining the stability of the same. For example, if they are creating bigger things into smaller things by mechanical manner or chemical manner, they are getting smaller things, and thereafter they are trying to make a kind of method or process to maintain its size, because they don't get agglomerated. So that itself another technology. That time, during the initial stage, that itself is not science, it is a technology. So not just novelty, new thing, but rather it is having inventive step. You have to create human, creativity has to be there. I'm saying human creativity has to be there to sustain, or you can have to maintain the smaller things which should never get agglomerated as a bigger one. That's it. So what I have to say is this technology was very at infancy, I can say, at very what I called underdeveloped stage, I can say, or a very at infancy stage 20 years back or 15 years back, we can say. Not for everything, for each domain. It varies from domain to domain. But now it has, for that time, the novelty criteria and inventive step is, the standard is very low. I'm giving an example to make you ourselves understand the standard is very low. Thereafter, now the domain has evolved such a way, it got established in many of the domains where it has become not novelty, not very much novelty. Inventive step may be there, but it is lagging in novelty. So the patentability criteria, it has to satisfy all the patentability criteria: subject matter, novelty, non-business, and utility. So if missing any of those things, then there is no guarantee for, there is no scope for granting any patent for the inventions. So what I have to say is the standards also keep changing. So the claims, very important. It is like fixing the boundary. A person gets the property, tangible plot in a way, and he fixes 40 by 60 or 120 by 120, like that. He fixes the boundary, or he fixes the boundary. Same is the case. Claim is the boundary of an invention, which is granted patent. Same is the case. Claim is the core on which all the things evolves. Claim is the thing on which the subject has been decided. Same thing. For example, we can have the same claim. I'm giving this example to make yourself understand. The same claim is protected in India, in America, Europe. The same claim, same invention, but subject may vary. Very important. Subject may vary, and the claim may also slightly may change. Same invention, I'm saying. The structuring of the claim also may change. Subject matter may vary, and it may be protected in different class. It may not be same. It may be protected in a different class, and the patentability criteria. For example, if there are core claims which can be protected in India, because the claims for patentability, the standards kept for novelty and non-obviousness is different. The standards kept for novelty and non-obviousness is different in Europe for the same inventions. Same is the case with the novelty and non-obviousness in case of in Europe and India we have similarity actually. Inventive step, they'll call it inventive step. In US it's called non-obviousness. Both are not same. What I'm saying, the name itself is different. They may have similarity. The name itself is different, but they have the similarity. And doctrines are also different. Their doctrines fixed for fixing the standards are different. I am emphasizing this. You people generally, some of the I know some of the CAs, what they did is they'll try to get the help of someone to draft the claims. It is not so easy actually. This put it this one, that one, you will get the things. It's not easy. It is only skilled people. Person from chemistry cannot adapt the claims for mechanical engineering. They can to some extent, but not to the efficient extent, I can say. Or they cannot draft the claim for physics inventions, invention from the physics background or invention from electrical background. It's not possible also. So each domains have the expertise in them. Initially, it was not so, because the invention during that time was at very, draftable stage. Now it has gone very much deep that it has narrowed down. Only expertise can draft. Now, another interesting thing has developed. There is different interfacing of different domains, which has connectivity of chemistry, connectivity of what you call physics, and connectivity of electrical domain. So experts from this interdisciplinary domain has to sit and write. No one can singly sit and write over there. 2-3 people have to collectively sit and draft the claims. In this scenario, the people from non-technical background, non-science background cannot, explore and put the inventor in problem. These are one things. Another issue is, very interesting thing, I want to say, litigation is thoroughly different ballgame. Specifically in IP litigation, I can say other litigation people are appearing before the tax authority can manage. I have seen many of the tax practitioners are, appearing for intangible issues before income tax authority and other GST also. Basically, income, they have a separate, bench to tackle intangible assets taxations actually. I have given these things so that you people can understand, both from the perspective of valuation, what we call liabilities, as well as the under which it has to be, classifications. Other thing is the nature associated with it. They will try to put it in different way and they will argue it. You people have to get the assistance of the technology expert in this one. It is not required in all the things. Technology expert in this one, so that they can educate the bench, tax bench, and how they are right and they are wrong. How they are right and wrong in getting to such conclusions. I'm talking about technology perspective, not about the taxation perspective. I'm talking about technology associated with the tax perspective. So you have to get the assistance so that the clients get some benefits out of the things. Because we will see that while discussing with them, we find very difficult just to make them understand, because their exposure and their way of understanding is different than the person with technology and science background. So what I'm saying is 2-3 expertise can get the things in a better level. So the bench also will get educated, and thereafter will get a better, output, and since the result will be better in taxing things. And another thing is, in case of I have told you the value. Latest, I was hearing 2 days back one judgment where the method and process, I can say, product and process, I can say, they have changed in one country product claim as a patent, process claim, and in another country they changed reverse. So there are legal complications when drafting or when interpreting in the things also. You will be very cautious, and how those things are to be understood from the commercial perspective also very important, where you might have given a kind of what I called agreement. Very important. This is very, very important. There are 3 claims. You might have given agreement for using claim number 1 for a third party, but a third party intentionally creates this agreement, but he uses the other 2 parts, because it is not like house where once they rented to a person 1 floor, we can easily figure it out whether he's staying in the first floor or second floor or third floor. It is not like that. But he may use second claim, or he may use third claim, or he may use the total invention also, or he may sublicense also, or he may violate the agreement parts also. We don't know. So it is the duty of the professional to check that whatever written in the agreement and whatever it is practicing or whatever he is trying to use is same or different. And there, if he is going against the terms and conditions, there are 2-3 options in all intangible properties. I can say we can move on a court. We can do many things. We can cancel the agreement, or we can go for modification of the agreement, or amendment of the agreement, or we can go for new agreement, or we can decide something for avoiding the impact. But for the wrong which has done, you have to go for injunction. Very important. Injunction, very important. Not use any of the things, for not to infringe anything further, injunction. Or else we have to do for, and then other called damages. Damages. Now damage is subject to 2 very important things, whether he has created revenue out of it, whether whatever now we are claiming for damages. We can say that damages is very, very big topic from the IP perspective. I can say we cannot go, oh, he has sold the material for 100 crores, he has used the claims 2 and 3, and he has generated 30% extra, then his normal revenue. We cannot go like that actually. That's a different strategy altogether. Damages should also include the compensation also, and also include the other things also, like damaging the goodwill, or for example, a person who has got license from the company of the well-established company, he can go much beyond that. That's what I'm saying here is, as a practitioner, we have to be very cautious. We cannot stick with the agreement. We have to go much beyond the agreement. So when we go for litigations or when you go for claiming damages, it is not narrow. It has the image, like we can see some sea animals, immediately structure will bulge and it sees the enemy, or when it encounters something which is dangerous to its survival, immediately you can see the nature. Also, you could have seen some suddenly its body structure will enlarge, or you can see the chameleon where it will change its color. So same thing. What I'm saying is the value associated with it will change, not just for infringement, but the damages and compensation will keep. I mean, the character of that, the litigations cannot be very narrow, it will enlarge to an extent. So they will claim more than what even they have done the business. If they have done the business for 100 crores, due to this usage of claim 2 and 3, they might have generated hardly 10 crores, but we can go much beyond 100 crores, 200 crores, 300 crores. But we have to make some reasons for it. We cannot claim, oh yes, because it is not like that. We have to calculate in different manner so that we can litigate in a strategic way that these are the things. And moreover, the agreement in case of intangible property is very tricky thing actually. What I'm saying, it involves many complex things, not just its jurisdiction. And for example, they might have assigned they will have a lot of litigations. They would assign to someone to other countries, but they may be having the bar in that litigations, in that assignment, or in the other agreement they encounter with the other persons. They would enter into agreements with different parties all over the world. They are doing business in different countries, but while importing those things from other countries, the person who has been already entered into an agreement here, he may sue for infringement. Very important. So the inventor, hey, you have given assignment to, you have given license to everyone. Same way, I got a license, but look here, because of your import and doing business, or someone's import and doing business, it may be any third person also importing and doing the business. There is a violation. There is an infringement. The product which you are licensed. So, and that's the reason while drafting, you have to draft that the who are all the person already been assigned, or I can say licensed or assigned, or any kind of contracts entered with. That has to be reflected. And what nature of contracts they have been, what nature of contracts they have been encountered, and how it should never be having an impact in the present contract to carry out the business. That's one thing. And if any such things occurs by himself or through any such person who entered the any third person who entered the contract, or any other person who are no way connected to things carrying out the business, how the legal issue has to be, faced. These things has to be reflected in the contract. It's more complex. It is not like importing the other tangible materials. It's though very important, it's a tangible material importing. But very interesting thing is, these tangible materials have the component of intangibility associated with it. That is the thing I want to say. It is a tangible material, yes. IP product is, but intangibility associated with it is very important. What I'm saying is the IPR connected with it, or other intangible connected with it, is because we are not just, that's the reason we are not just selling the product, or we are not entering a kind of trade things just with that product. There are associated things which will have the impact. That's the reason I told, while going for a litigation, they should never go for just the claim 2 and 3. There are related associated things with the IP, intangible property, or intangible assets. There are other things associated with it which can have many impact in his business all over the world, and other, it will have impact not just on that IP but other associated IPs. So while drafting the agreement and while litigating the same, or while we are challenging the agreement, or while we are cancelling the agreement, we have to draft it in such a way that the interest of the client has to be reflected over that. The future forecast, that these are the things we have to see, what are the future forecast it could have the trans-border transactions. Very important commercial activities associated with it. Now, what I am saying is, the injection will be there, and then damages we can claim, and even your, for example, the terms got over, the contractual terms got over, but still you can sue them. Different perspective, very important, and different perspective, where they have damaged. For example, another more interesting thing also say, there are bunch of IP, because generally they don't give a single IP, there will be bunch of IPs where I have the different life period. But this is very serious. I am selling some trademark associated with it, and a patent associated with that IP. I am entering an agreement with the X person at different countries, or in the same countries also. There are a bunch of IPs, but as the time, the period of life associated with them are different. Trademark, it can be renewed. Patent, it is 20 years. So what I am saying is, design is also there, 10 years. That is subject to another renewal. But what I am saying is, those are, we are sending, putting your different animals, cat, rat, elephant in a cage. We are giving more value to the elephant and lesser value to other accessory. But after a few years, the other animals will die. So how are we going to, how they are, I am saying the analogy, so that when they are selling the things, there are many other components which are, incorporated in this ones. We have to see the life period and ensure that other things also, the life of other things also get extended, or write a very important component in the agreement that how it has to be tackled. When the life period gets over, how it has to be tackled, the agreement of license. So the agreement for license of the IPR. Otherwise, what they will say is, they will just go to, it is already lapsed, and the smaller thing only we are using, we can pay lesser amount, or they can deny paying the amount, or they can say that we are not using. Similar things we encounter in the practical things. That's the reason I am saying these things. And they used to stop paying the, the amount which they agreed to pay as per the agreement, or any royalty amount, or any license amount, whatever the things. So we have to be very cautious in drafting each component when they are going for licensing bunch of IPs. And in this background, I can say that, and moreover, this is one thing, management of assets is another thing. We have to, I have already told you, we should never waste money on managing the IP assets where no money can be generated, or less money can be generated, or without its life we can generate the money. So we have to be very strategic things, all those things. And the other thing is litigation. For no purpose, they will fight. Business people for no purpose. Today I was discussing with, they're good friends in the business. They will talk a lot of things, but they filed a suit in the court. They're litigating, happily litigating. We are paid for litigation. That's a different issue. We are paid for litigation. We are also happily litigating for them. But when they are saying, okay, let the litigation be there, let us decide thereafter. They're ready to lose and they're ready to win. But they're playing in the court. But there are many reasons for it. That's a different litigation strategy for survivability of their business, the field, the market, for survivability of their business movement. Very important. They knowingly do it. They intentionally do it. We cannot say no to them. But we have to tell them what are the outcome, what are the implications. Sometimes it may give the, good outcome. Sometimes it may end in reverse also. We have to see, we have to think about it. We cannot forecast the judgments, but we can say that if the judgment comes in the positive manner, in the negative manner, how it can impact. You might have seen, they will let other opposite people to keep infringing. Infringing is, I will say that infringing is a big domain where many litigations goes on the infringing only. How they infringing the trademark, or infringing the copyright, or infringing the patent, other things. Moreover, this all the IPs are not positive rights. Actually, it's negative rights. In the sense, it has to be licensed, or compulsory licensing components are there, so that the public, it should be for the public utility. Commercial activity has to be carried out, and income can be generated, but should never bar it. You should never bar others using it when there is a scarcity, when there is more demand, and means to avoid the monopoly, market monopoly. Anti-competitive policy has to be, has to be kept, a check on anti-competitive policy, practice in the market. So these are the things which you have to understand. During IP is not just single thing, it is having many components, and there are many associated things with it. And we have to, cannot look it into a narrow perspective, and we cannot see that it is having it's a different altogether game, a different game, and we cannot say that okay, these are the things, that are the things. We cannot go to the, just stick with all the statutory protections. We have to go much beyond that. That's the things. I think I have given some idea. Another 5-10 minutes we can go for the questions if you people have anything. Sir. Hello, sir.
Sir,
Are there any questions, sir? I could see one question here.
Sir, one question in chat, one question in Q&A.
Yes, 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 sir. I myself have answered for it because I find I don't want to name the company.
Only one question, sir.
So it is a trademark issue. They filed actually. There is no trademark infringement actually. They intentionally filed actually. It's a big company, global company. It's a small startup company, not startup company, small company running for more than 15 to 20 years. They're a well-established company in Karnataka. But a person has filed a case in Delhi High Court for trademark infringement. There are no similar activities in from the perspective of the trademark or from the perspective of the business or from the perspective of any other competitive or any anti-competitive practice. Nothing. They're totally different, but they filed it. They succeeded in it. And I don't want to make whether anything on the judgment, but we accept the judgment. But the issue is at nascent stage. Understanding of the infringement is yet to evolve. The jurisprudence has yet to evolve how they are deceptively similar. From the perspective of name, from the perspective of look, from the perspective of the business, and even from the perspective of other activities, how they will say software. What do you mean by software? Software is such a big domain. They are doing similar activities. They are doing similar. What is this thing? Code has to evolve further. Since our client is not big, I mean, they're small startup, as I said, it's a small player. I mean, judicial player, actually, very small in and around inside Karnataka, and small clients in and around Karnataka, and few clients from abroad. Very small, meager amount. And at the end, he decided, I mean, he lost in a way. I mean, the loss is not acceptable in a way. What I have to say is, the jurisprudence has not yet evolved to understand each domain. How it may be on same class, under same class, but how they are different in doing the business. But anyway, we have to make it understand. We have to evolve further. We hope that things will evolve. The judicial, these are unnecessary litigations. So we know that. They also know that. But this is how the big fish will try to eat a small fish. That's how the big fish is to survive in the market. This is another litigation strategy. There are a few more things I can say. Since I am from Karnataka, I can easily say this small case which we handled here. Very important case, in fact. It's not a small case, important case. So, sir, are there any questions? I have given a brief idea about connecting different dots in IP. I don't want to give all patentability criteria or copyright, life, GIF, you can find it on internet also, but these are something which you cannot, we have to go hundreds of hours to read it and get it connected yourself, which I did it for you very easily, I hope. And you don't think that it is IPR means only these three things. There's few things like patent, trademark, copyright, designs, GI. It is not like that. It's very different. Yes, sir. Having answered this question, single question, are there anything which I have to do, sir? Hello, sir.
Hello, sir. 1 minute. Hello.
Okay, sir. Answer, please.
Hello.
Please, sir.
Yeah. Members, if you have any questions, we can ask. I think there is some questions, sir. I'll just check out, sir.
Please, sir.
In this month.
Questions ಏನಿದೆ? Questions try ಮಾಡಿ open ಆಗ್ತಾ ಇಲ್ಲ.
Are bigger companies like Amazon?
1 minute. Question. Sir, one question is there. Can I read out, sir?
Please, sir. Please, sir.
Sir, you are on mute, sir.
No, sir. Am I audible, sir? Am I audible, sir?
Venkatesan, sir.
Yes, sir.
Hello.
I am hearing you.
Hello.
I am hearing you, sir. I am
Yeah.
hearing.
One question is there.
Please, sir.
all bigger companies like Amazon, Walmart, Flipkart are creating unnecessary litigations, representations by challenging the trademarks and copyrights, even though which are not identical to them. Being a small business holder and startup may not be in a position to fight against these people. Any statutory protection can be claimed from this without litigation. From Shaker.
Sir, I have told you within a current example which I handled the case. I have given the current example which I handled the case.
Okay.
Business strategy, very important. Litigation is not just, business is not just a business. They have to have a certain litigation strategy so that the big will try to encroach upon the market established by the smaller fish.
Okay.
I can say the big player try to establish their market because it is very difficult for them to intrude into the smaller markets. So they, by litigation, they will demolish them from the present local field by, irrelevant litigations, and they'll try to get some kind of orders in one way or other, or they'll try to force them to compromise. And they have the battalions of big lawyers where they spend crores of rupees. Very important, crores of rupees. To take it, let us take it in a national parties, swallowing smaller state parties. Simple. This is the thing. Split
Even
it.
negative marketing also, they'll make it a brand.
Everything they will do. That's
By
a
doing it.
business strategy, actually.
Okay.
And in practice, they will do it. They will file false case, or they'll try to put them in a different situation. They are forced to budge before them. This I have learned after coming to Delhi only. Oh, these are the things they are trying to do, all those things. So because we don't, in South India, it's very difficult. People don't do all those. Maybe small people do, but majority don't. There is some ethical, professional ethics, business ethics they are doing. But it is not here when we go for a different. This is what I feel. I understood by facing some of the cases actually here. And
Sir, I have one question.
please, sir.
If you have taken any patent within India, in India,
Okay.
how much time it will take? If I'm going for international patent, how much time it will take?
Sir, actually, sir, normal course will take 3 years to 4 years, but now they quicken the process. We can get within 6 months to 9 months. If you pay, that is some extra money has to be paid. So that there is a what you called a tractor scheme kind of things. Within 9 months, you can get it maximum if they process in quick.
Within the country, within the country.
Recently, around within 6 months or some, it's very, within 8 or 9, we can get it. Within 6 to 9 months, we can get it in a faster scheme.
Sir, between IPR and trademark, which is the stronghold?
IPR is a bigger domain, sir. It has a lot of things like trademark, copyright, everything. I'm not getting your question, this one, which is?
No, trademark registration, if some company has taken,
Okay.
another company for same logo or content, they have taken IPR. Which one will hold good, whether trademark person or IPR person?
Sir, IPR is a composition of patent, trademark, copyright, all those things. I have to get it. A person has taken a trademark for one thing. I'm not getting the question clearly. Sorry, sir.
Company A has taken a trademark on some logo or content, sir.
Okay.
Company B has taken on same logo or content IPR rights, sir. When they both compete between company A and B, which one will be in stronger position?
Same thing taken by different two people.
Yes.
You are saying which one will hold? There's priority, sir. Date of registration, or for example, anyone who has already done the business on the trademark, they will have more right. For example, A is carrying out the business, but they have not registered. But B is taking a trademark on the A, which already doing. A will have a right over it, and he has to, submit those documents before the trademark authority, and they can cancel that trademark obtained by B. This is just things. If it is not cancelled, then he has to litigate before the, by way of, before the court, and they get the relief.
Among IPR and trademark, which is the superior body and which is the stronghold, sir?
Sir, actually it comes under, no, I'm not getting actually, a trademark is one of the small IPR authority, sir. Trademark authority, yeah. IPR is a bigger one, sir, where and is given, GA is given, all those things are there, no, sir.
Okay, okay,
That is bigger authority. Trademark is smaller authority within that one.
okay, okay.
Bigger or smaller, everyone has been assigned certain functions, duties, functions. That's it.
When we want to go for international patent,
Okay, sir.
we have to hire local or we have to interact with other international consultants for that, sir? How?
Actually, sir, we have to hire the expert in that field. That's it.
Okay, okay.
It is important whether international or local. Expert can draft it
Sitting
very
in
nicely.
India, we can apply for that, for international
Sorry, sir?
patent.
Sorry,
Sitting
sir?
in India, we can apply for
Yes,
international
yes.
online or
Online now, everything is online.
okay.
And there we have to get the assistant of their local jurisdictions. That is easily possible with this now connected things. Yeah,
But,
it is. We are sitting from here. Yes.
Yeah, as per my understanding, it's very gray area. Lot of things is not clear. Are you agree with my question, sir?
Yes, sir, I agree. Yeah, I have told you, no, sir. Actually, I came with a basic idea about IPR. Thereafter, I evolved from here and I have understood the different dimensions altogether. And what I understood is a very minuscule. It is very different things altogether. To make ourselves understand, Google is running most of its business with only IPR. Yahoo, Google, all big people. That's the things. No tangible materials are, no tangible assets are required. Only except office to run the things. Other things are everything in the clouds now. It has gone to the extent of clouds. Understand?
Okay. Thank you, sir. Thanks a lot.
Sorry, sir. Thank you. If I have within the 2 hours, I can make some reasonable justice only. I could not. I don't want to get into the routine way of making to expose to the IPR type protection. These things people attend and get anywhere. But what I did today, it's I have done a different thing altogether.
No, sir. IPR is a ocean.
Yes, sir. Yes, sir.
It's required. Even 1 day session also is not sufficient.
Not sir.
But you try to fit it everything in 2 hours. Really, I can understand that.
Yes, sir. Whatever possible, sir. Yes.
I thank for your time and efforts in sharing your valuable notes in your busy schedule. I thank on behalf of Bangalore branch of ICA for sharing your valuable notes, sir. Thank you. Thanks a lot.
Thank you, sir. Thanks for all the organizers and thanks for all the participants to be with you this evening. Thank you, sir. Thank you.
Great time to be with you, sir. I thank all the members those who actively participated and made this program successful. Thank you. Thank you all.
Thank you, sir. Dhanyawad.